Hi, welcome back to the podcast HOA Hell. I'm your host, Michael Kushner, and with me as always is Senior Associate from MBK Chapman, Sam Kill. Sam, good morning.
Good morning.
So today, Sam, we are going to, I turned a recent fact sheet into an episode because I think it's a really important one. I will put the link to the fact sheet that basically underpins this episode in the description. But that fact sheet and this episode are both going to focus on the 5 biggest mistakes that homeowners make when dealing in disputes with their HOAs. So these are the 5 real-world biggest mistakes that we see. This is an important episode, as all of ours are, because this is the stuff we're seeing in the real world, not the ivory tower stuff that a lot of people like to talk about. This is real stuff.
Happens all the time, daily.
And there are lots of mistakes that lay people make, dozens, but these are the top 5. Okay. Now, the order that we give them today are irrelevant. Okay. The order's not relevant. These are just the most common of all of the mistakes that homeowners make when dealing with their HOAs and there's disputes with their HOAs. These are the top 5 in no particular order. Okay. But we're going to talk about what those mistakes are and why each of those mistakes does so much damage. That's the focus today.
Yeah.
And what's important, in addition to just you should know things to avoid, another important reason for this episode is because we're going to help you understand why these are mistakes. In other words, we're going to explain why, even when you have the facts and the law on your side, making these mistakes could torpedo your case before it even starts. And that's what we see a lot, and it's such a shame when I say torpedo, I don't mean ruin forever, although that can happen depending on the nature of the mistake. I'm talking about you could have resolved this for a much lower sum of money than after it comes to us and you've done the damage. And so I'm going to try to, if I could get one person to recognize themselves in any of these and avoid doing this, I'll have done, I think, a good day's work for purposes of our podcast.
Good.
Okay? Now, this episode in part then implicitly is involved with what homeowners do to strengthen the HOA side, which is what you don't want to do. Okay? Let's go with mistake number 1. Refusing to pay HOA assessments.
Oof, massive.
That is mistake number 1. When we say assessments, we're talking about general assessments, which is otherwise known as your regular dues, or special assessments. We're not talking about fines. Fines are not assessments. Assessments are your dues, and special assessments, failing to pay those, no matter what, is the number 1 mistake. And by the way, contrary to what I said a minute ago, it is the most important and most common thing we do see and the most destructive. So at least me mentioning it first is on purpose.
I see it daily. Huge mistake.
I see it all the time.
Yeah.
And I've seen it for years, and it's such a shame. Let me be perfectly clear then, okay? I don't want there to be any confusion about this point. You are never, ever permitted under the law in the state of California, when it comes to HOA assessments, to withhold an assessment, no matter how right you think you are. It is a universal, absolute fact. California does not have a right of offset. You cannot, no matter how legitimate your complaint is, you cannot withhold the payment of an assessment. So, to make that point, to drive it home even more, let's talk about this. Even if all of the following are true, everything I'm about to list in this list is true, you cannot withhold an assessment. The assessment is completely illegal. It is coming from a bad HOA. Give me a couple.
They're unreasonable. The board did not hold elections or follow their own election rules and procedures.
If it was over the 5%. That's
Exactly.
right. If it's unfair, if they violated the law in some way in imposing this assessment, even if all those things are true, you cannot withhold payment. Okay? HOA members do not have a right of offset.
They do not.
Period. End of story. Full stop. Use whatever, cliched, hackneyed writing trope or verbal trope you want. You can't do it. Have we been clear about that?
You can't, and you cannot reason your way around that. It's absolute. It's unequivocal.
In fact, when you do that, folks, when you refuse to pay, even if, again, all the things we just talked about were true, it's illegal, they didn't follow procedures, it's unenforceable, the courts will strike it down. Even if all of that is true, when you refuse to pay, you give the HOA massive leverage and you put yourself in tremendous disadvantage legally. And what do I mean by that? Because before you ever get to a court that could rule on the illegality, unenforceability of the assessment, the HOA has a right to come in and impose late fees, interest,
collection costs,
attorney's fees.
They can suspend privileges. They can impose a lien or record a lien
against your property.
Initiate foreclosure proceedings.
Exactly.
Yeah.
You could lose your house. Let me tell you, when they record a lien, that's a public record, that will affect your credit. Okay, credit agencies routinely look at the public record. Okay, they don't have to report to the credit agencies for the credit agencies to eventually see the lien. It could materially affect your credit. And you said foreclosure. It could foreclose. That is end of story. You could be 100% right, and it doesn't matter. That's what you're facing when you don't pay an assessment.
It can be highly prejudicial, impact lender actions against you.
Right. You might think that you're punishing your HOA by withholding. No, you're punishing yourself. Don't do it. Don't do it. Don't do it. And when you do it, and we see it, like Sam said, every day, you are costing yourself so much more money to resolve the underlying dispute that, again, you might be 100% right about. Okay? So that leads us to the if you remember nothing else statement. Here it is. If you remember nothing else about this first mistake, pay first, no matter what. And then second, challenge the legality of the assessment. Okay?
Agreed. Absolutely.
Obviously do that. Now, I want to be clear about one thing before we move on to mistake number 2. You don't have to use any magic language to preserve your rights, like write something on the check saying, I'm paying this, but I'm disputing it. That is false. Right. You do not have to. You don't waive any rights by paying an assessment that you think is completely false, illegal, unenforceable, unfair. Use whatever adjectives you want. You don't have to affirmatively reserve rights. You always have the right to challenge the legality. Make the payment, challenge it later. That's it. Remember nothing else.
Absolutely.
Do that. Mistake number 2, failing to create a proper written trail. Now, Sam, especially at the beginning, the first maybe 20 episodes of our podcast, and right now we're at over 200, Sam used to love this one. Document, document, document.
It's a biggie.
It's a biggie.
Yeah.
Lawyers like us often forget that lay people don't live in our world. They weren't trained to think the way we are trained to think in law school and then years and years of legal experience as lawyers. In everyday life, normal people rely on verbal conversations, informal discussions, hallway talks, phone calls, handshakes, informal promises, that sort of thing to kind of move through life. The problem is that when you're in a dispute with your HOA, these are evidence-driven. Okay? And evidence-driven disputes require documentation. They require evidence. Because I assure you, no matter how honest you think somebody is, no matter how on your side a director or a neighbor or whoever you think is, people lie under oath. The conversation that occurred where somebody said X, Y, and Z that you're relying on, assume they're going to lie under oath. Just assume it. If they don't, great, but assume they will.
And that problem is even more amplified with HOAs and HOA disputes because you have so many people involved. You may have neighbors, committee members, prior boards, current boards, and revolving door management representatives, attorneys.
Exactly.
So it's important to document.
Exactly. Okay? People lie under oath all the time. Once you accept that fact, you can set yourself up for success by avoiding one of the biggest mistakes that homeowners make in terms of documenting their cases or their disputes. Those mistakes that we see every day that you need to avoid under this mistake number 2 include things like failing to confirm conversations in writing. As simple as you have a conversation with a manager where the manager makes any substantive representation just follow up with an email that says, hey, great talking to you this morning. I'm looking forward to your doing X, Y, and Z as we discussed, after which I'll do P, Q, and R. Mm-hmm. Just confirm the material points in writing. That's all you have to do. Nobody has to sign anything. These aren't contracts. You're just sending it. It could be an email. It could be a text. Text is writing. Mm-hmm. Text count. Or it could be a formal letter, although I prefer something that you can prove got delivered. But it can be anything as long as it's in writing. So failing to confirm a conversation after the fact is a massive mistake. What's another one that people don't do?
They don't take photographs or record things contemporaneously, like video.
Legally and obviously preserving, following, and I've got fact sheets on this as well. You could look on our website under the libraries tab and type in surveillance. There are, we're a two-party state. You can't record unless you're doing it obviously. You can't record without permission of, all parties. But assuming that you've done all that, take pictures and video of conditions that are at the center of the dispute, for example, okay?
Exactly.
Failing to preserve or back up emails or texts. If you've got important texts or emails regarding a dispute that's kind of starting to boil, make sure you back up your phone or back up your computer or back up whatever in the cloud so that those emails don't get lost if you need them. Okay.
Anything that involves reports, police reports, citations, vendor reports, inspection reports. Keeping them.
And organizing them.
And requesting them. Sometimes they're not issued. You just get an invoice for something.
Right.
So,
Failing to maintain a timeline or an incident log. Do not rely on your memory. Okay. Memory. I mean, I have trouble sometimes remembering what I had for dinner last Friday. Don't count on the fact that you're going to remember nuances and important details a month, 6 months, a year. So if you're in the middle of a dispute and you know it's becoming something that you might want to take action on, keep a log. Who you spoke with, the time of day, the date, whatever. Keep a log. It doesn't have to be detailed. It just has to be enough to spark your memory, okay? Failing to document recurring issues in a timely fashion. If you get correspondence and you don't respond, if somebody says something like, hey, you agreed to do this and you didn't, you've got to respond saying, well, wait, I didn't agree to that. Here's what I agreed to. Okay, fixing that record. So if you remember nothing else about this mistake, if it's not in writing, it never happened. Say that out loud. I'll wait. Okay, if it's not in writing, it never happened. I've been teaching that to my employees for the last 15 years. If it's not in writing, it never happened. I never, ever want a lawyer telling me, we're good, I've confirmed XYZ with the client or with opposing counsel, unless it's also in writing. If you did it by phone, that's cherries on top. It is not a substitute. If it's not in writing, it didn't happen, end of story. Remember that. Okay? Mistake number 3, believing HOA myths that you see online or in social media instead of relying on trustworthy sources. Now, that's a loaded mistake, so we're going to break it down. The internet is a cesspool of misinformation. Do you agree?
100%.
Okay.
See it all the time.
And yet, you out there would be amazed, Sam wouldn't be, but you would be amazed by how many people get their advice, I use that in quotes, their HOA advice from, give me a few.
Well, this happens all the time. Facebook, Reddit, a neighbor's page, just someone typed an essay somewhere online, put it out in the ether.
An article.
Could be
a neighbor.
Exactly.
A board member.
Yeah. I mean,
how about this?
Endless.
How often do you see this, Sam? People have typed their issue into an LLM, a large language model like ChatGPT or Gemini. They use AI and they come up with their answer and they rely on that.
Daily.
Especially
every
my day.
Console these days, people will walk in
with printed out.
A printout of those
I can't tell you how often, and it's going to get better as time goes on.
Yeah.
I can't tell you how often Gemini, ChatGPT, Claude, and other LLMs are dead wrong. Just 100% diametrically wrong, as in massive hallucinations. That's what they call it when AI gets things dead wrong. Those are hallucinations. You cannot rely on anything you read in AI unless you have verified it through independent sources. AI is not trustworthy yet, okay? Now, It doesn't mean it's not a valuable tool. Doesn't mean you shouldn't use it. But you've got to verify independently.
It does a lot of impressive things, but it also, unfortunately, in my experience, recycles a lot of nonsense. Yeah.
And I'm going to prove it to you.
Mm-hmm.
The following quotes are from PCs or clients that we've had in the last 6 months. And they are all related to things that they learned on ChatGPT, Gemini, or Claude. Those 3 LLMs, large language model AIs. Quote number 1, you can withhold assessments under certain conditions. End quote. False. We already told you that. That was mistake number 1. HOAs can't foreclose anymore after AB 130. False. Completely false.
Egregious.
Egregiously false.
Yeah.
CC&Rs override California law in some cases. No, never. Okay? HOAs can no longer recover attorney's fees in most cases. False. Depends on the nature of the claim. I've written extensively on fee-shifting statutes, which is another way of saying who gets her attorney's fees when a party prevails in a lawsuit. I'll put a link to that one in the description to my most recent one, where I actually listed every single statute in the Davis-Sterling Act that had a fee-shifting provision. Mm-hmm. And I explain how it applies. So you might want to take a look at that. Okay? HOAs can't fine homeowners after AB 130. Wrong. Mm-hmm. Incorrect. False. Homeowners must always engage in ADR before they can file a lawsuit. Now that one was not only spread through AI, but it was spread because of a very prolific professional promoter, the bad HOA lawyer that I have featured in multiple of my fact sheets online. Look for any of my fact sheet pictures which features a clown. That's who I'm talking about. Or in prior episodes, a couple times we've talked about the bad HOA lawyer, who I've also termed the professional promoter. This person famously wrote about an obligation for all litigation cases against HOAs to require ADR prior to filing. That's just not what the law says. It's just dead wrong. Dead wrong, 100% wrong, okay? Which leads me to my next point. In addition to relying on or not relying exclusively on AI or social media, because you have no idea who's saying what, mm-hmm. Even if the person's presumably appears to be a so-called expert, they come up number 1 on Google for all these HOA things. It doesn't mean that they're right. Verify. This is a good time to use AI. If they say something, verify it with AI, see if it comes up with the same answer. If it does, I'd still look somewhere else. Mm-hmm. I will tell you this. I'm trustworthy. If you use in this self-serving statement, I acknowledge it here and now. If you look at anything I've ever written, it's going to be accurate as to the law, because unlike many others, I write my articles and I write my fact sheets. I do not have AI write them for me. Everything that goes out under my name is written by me and vetted by me. And I research it, and I've read the statutes I cite, and I've confirmed. Now, it doesn't mean I don't make mistakes sometimes, but when I catch them or they're pointed out to me, mm-hmm. I do correct them. I had somebody point out a mistake we made in a recent episode on the foreclosure issue. We had one of our listeners on YouTube point it out. I wrote back to her that you're absolutely right. That's a mistake on my part. And then I went and I actually added in the description to that episode an acknowledgement that I'd made a mistake. I do make mistakes. When we're talking, sometimes we speak and we don't necessarily. I outline the points I want to make, but I don't script this. This is unscripted.
And you can only cover so many nuances.
That's right.
Yeah.
But we make mistakes. But when they're pointed out to me, they're corrected. For the most part, I can't identify any existing mistake in anything I've ever written because I would have corrected it by now, mm-hmm. right? That's another thing on that professional promoter, bad HOA lawyer. Even though I've written extensively on the many errors that this person has created, going back and looking at the articles that I specifically pointed out, he's never changed them. And I know he's aware, and I know that he covers it because whenever I do a topic, he seemingly does the same topics. So it's not that he's not aware of the things we're writing. It's just I don't think he cares. Bottom line, though, rely on trustworthy online sources. So if you come across somebody new, somebody that you haven't vetted or come to know, verify until you can confirm that this person generally does good work, then you can trust them. Okay? What's another one? What do most of my fact sheets do vote, pretty routinely? And then I'll give an example if you can identify it.
Well, look for citations to statutes,
Yes.
legal authority,
Right.
and things that are objectively verifiable.
That's right.
Yeah.
Now, I don't, as a matter of course, I never cite cases in any of my fact sheets because I don't expect lay people to be able to find the cases, and even if they could, to read a case, because it does take training for the most part to learn how to read them effectively and learn what a holding is and all that. What the difference between dicta and a holding. I don't expect lay people to know that, so I don't cite cases, but I cite statutes all the time, religiously. Mm-hmm. Somebody that doesn't cite statutes, to me, is not trustworthy. Okay? Now, let me give you an example. Okay? In a recent fact sheet I wrote as part of a 6-part series on HOA nuisances, I was covering certain crime-related nuisances. And obviously, in the different bullet points in my fact sheet, I cited various penal code sections and stuff like that, okay? Because I always include statutes for any homeowner that's reading my stuff that might want to look for themselves as to what I'm talking about. Mm-hmm. So I provide it. I don't quote from statutes. I cite them. I might say something like under Civil Code blank or Civil Code blank requires. You can go look at it if you want. You don't have to, but you could because I give you that code section. And I'm basically inviting everybody to check my work.
Yeah.
And if you want to, do so. People that don't cite the law or cite very seldomly, when it's clear it can be done.
It's a bit of hiding the ball and not empowering or enabling the potential client, audience to independently verify and substantiate, that you stand by your work. And,
exactly.
And it speaks for itself.
Okay. Yeah. If an author is writing in generalities and doesn't provide nuance, where nuance would help give context, or doesn't provide real-world examples of something that they're saying, here's the law, and then giving you an example of how it's applied. If they focus on the obvious, they tell you stuff that you already know. It sounds great, but they're not. If you ask yourself at the end of reading it, did you learn anything that you could put to use immediately? If that's what you're reading, walk away. It's not trustworthy.
Yeah.
Okay? And that's obviously the reason certain people write that way is because they don't have depth of knowledge to do better. That's how you tell. That's one of the great ways to tell whether somebody's competent. Mm-hmm. Is do they provide examples and nuance and details and give you real-world information that you can apply to your own situation? If they speak in generalities and provide you with obvious statements, HOAs have lots of power, and they leave it at that, and they don't explain what that means and how it can be changed or what you can do to even things up, then what good is it? It's telling you what you already know. Then I would say, if that's what you're saying, less trustworthy, okay? Mm-hmm. Now, mistake number 4, turning HOA disputes into emotional wars instead of strategic ones.
Yeah.
Now, I think we can acknowledge that by the nature of what we do and the nature of what is an HOA dispute involving people's homes, they are emotional by nature.
100%. Okay. Homes, families, dogs.
It's all
neighbors,
Yeah. You're dealing with disputes involving your kids, your house, what you can and can't do with it, your pets, what you're doing wrong or right with it, or you can't have it or you can. These are all emotional issues. These are, you'd be crazy.
Your reputation throughout the community.
Everything.
Yeah.
Okay. Mm-hmm. So we know that. So this results naturally, understandably, results in homeowners who send hostile emails when they believe they've been wronged, or homeowners who make personal attacks on directors or managers. Mm-hmm. And they might, by the way, be completely correct. Okay. Yeah. They scream during meetings. They use profanity during meetings, during open forum, for example. They post inflammatory accusations online, on Nextdoor, or on Reddit, or on Facebook, or whatever, okay? Or they threaten lawsuits impulsively. As a matter of course in their emails, if you don't do this, I'm filing a lawsuit immediately, and I'm going to seek $1 million in damages, stuff like that. Or even worse, and we've seen this, they send so many emails, so much repetitive emails.
That's a big one, yeah.
And they throw the whole kitchen sink into every single one that eventually they get one of those letters from the lawyer for the HOA or from management saying we're no longer going to respond to you, which is a whole nother set of problems.
Exactly, yep.
Those are what we're talking about, right?
100%. Fastest way to prejudice and undermine your
Tell me
yeah.
what homeowners should do instead of that.
Absolutely.
And be specific.
First off, remain calm and try to take the emotion out of it. Be reasonable. Be comprehensive in terms of the facts, the authority, citations, let's say, to governing documents, if you're alluding to something within it, or alternatively, if you're asking for authority, do so in a very calm, objective, reasonable manner. So
not as a demand, like give me.
And in my view, a good barometer, I mean, you put one earlier, the mantra of if it's not in writing, it didn't happen. On this one, what I like to go to is treat it as if a judge will see it someday.
Treat it as if this will one day get in front of a jury and you don't want to look like you're crazy.
100%.
You don't want to look like you're unreasonable. You don't want to look like you don't want your credibility being attacked by making personal attacks as opposed to keeping it all business.
Yeah.
Assume everything you write to a manager or an HOA director or a neighbor, assume that a jury or a judge is going to see it when it's entered into evidence. How is it going to make you look?
How will it reflect on you?
And how's it going to reflect on your case?
Yeah.
Exactly. Great answer. Couldn't have said it better myself. If you want to lose your temper, be emotional, do that first, then scrap that and do the next one. Now, that is a great way to use AI, by the way. You take an email that you've written that's full of emotion and other things, copy and paste it into ChatGPT and say, okay, this is how I feel. I need you to prepare a professional email to the director. Here's the dispute. Turn mine into something that will give me credibility. And ChatGPT and Gemini and all those, they do a great job of stripping out the emotion and giving you something that will at least preserve credibility. That's how you use AI. Do that. Do not send personal attacks, emotionally driven demands, or make demands that are not supported by the law. Okay? This is why my fact sheets, for example, where I cite the code, are so useful. When you write and you're making a demand, you're pointing out you did this illegally or you did this wrong, that's when you use my fact sheets.
Absolutely.
Cite the code. You don't have to quote me. You don't have to send them a copy of it and expect them to read it. Paraphrase. You don't have to give me any attribution. Those are for you. Just put it in. That's how you do it. Get the emotion out, get the attacks out. The facts will speak for themselves. If an HOA director is embezzling like crazy, it doesn't mean you can't say that you believe he's embezzling or she, but you don't want to call them, you're a fraud, you're dishonest, you're a piece of this or that. You don't have to do that. Just say, based on the evidence that I described above, I think what you're doing qualifies as embezzlement. That's illegal, and I'm demanding you step down. Stuff like that. Keep it professional. Let the facts speak for themselves. Eventually, a trier of fact, a jury or a judge, is going to look at the facts and make a determination as to the individual that's involved. You don't have to do it. Let the court do it. So, great. Always assume they're going to see it. Okay? Just remember this. Emotional homeowners focus on winning arguments as opposed to being right and proving it. They focus on winning the immediate argument, not the war. They want to win the battle, okay? They want to vent frustration, and they want to call out specifically directors they don't like, okay? Smart, strategic homeowners document. They cite facts, verifiably. They cite statutes. They cite specific provisions of the governing documents that are at issue in whatever the dispute is, and they provide other sorts of similar type of evidence.
Yeah.
They don't just make bald-faced accusations without factual evidentiary support. Okay?
And the process we're recommending in espousing will coherently and methodically set you up for success. Absolutely.
And last mistake, number 5, waiting too long before talking to a qualified HOA attorney. Now, I'm going to start this by saying, by definition, this mistake is going to necessarily sound, and it is, and I'm acknowledging and admitting, very self-serving. I am an HOA attorney. I developed and created this homeowner-side HOA attorney niche in California. I believe we were the firm that I started and ran in the past, and then brought into my current firm, MBK Chapman. I'm the one that created this niche in California. It really didn't exist before me, as far as I know. And I'm saying this is self-serving. If you've got an HOA dispute, you've got to go to an HOA attorney, an expert on homeowner-side HOA law, like us, and you've got to come early enough before you've torpedoed your own case or waived rights or missed statutes of limitations or other things that people do to destroy their case. So forgive me, I am going to be self-serving for this part, but it's still important because you wouldn't I don't think you could believe how often we see people come in and they hire us and they spend a good deal of money to have us fix what they've done wrong, then get to the material meat of their matter. Why not just not have us have to fix what you did wrong, get us involved early enough so we can focus on the meat of the matter?
Well, it's one of those a stitch in time saves 9 or an ounce of prevention. Even if it's
worth
advisory,
a pound of cure.
Exactly. Even if it's advisory or guidance oriented, so that you can avoid those common missteps and pitfalls. That's really valuable.
Give me some of the benchmarks that we see people hit. They should have come to us earlier.
Well, they come to us, let's say, pretty far in the game in terms of, let's say, not paying their dues or going back and forth, and now they have a lien hovering over them.
They've already got a lien.
They're, the issues on the verge of foreclosure. Not only that, but they got really emotional. Some of the things we described, they got a cease and desist from the other side. They have documented their side, through numerous emails and documentation.
Right. And you've now got a letter from management or lawyers saying, you're not permitted to speak to us anymore. And again, we've done an episode on that in the past about the wrongfulness of that. But we're not here to talk about that. But the fact is, you've gotten that letter. You've gotten one of those harassment letters from the lawyer demanding that you cease and desist. So they come to us after the lien's been recorded. They come to us when they're facing the foreclosure, sometimes imminent. Could have come much earlier. Or they've already got attorney's fees assessed against them because of failure to pay. Or there's that one-sided paper trail that's been built by the HOA and you don't have the counter for it. Okay. You've already had hearings and been fined multiple times.
Exactly. Yep.
Or you've locked yourself into positions regarding important factual matters that would have affected your potential remedies and rights. And you've locked yourself in. In other words, in order to come up with the opposite would make you look, it would attack your credibility when, in fact, you weren't right to begin with. You shouldn't have locked yourself in that way because your way of seeing things wasn't even accurate.
Exactly.
But you lock yourself in and your credibility suffers.
You've engaged in self-help measures that you're not entitled to.
Exactly. The things that could get you in more trouble or that weaken your case because now the focus is on what you did wrong and not what the HOA did wrong.
Exactly.
It's so much better when it's clear that there's one right and one wrong. We're right, you're wrong. We're the good guy, they're the bad guy. But when you're also the bad guy and the good guy, then they're also the bad guy and the good guy. Now it's split down the middle.
And
you've weakened yourself.
Without assistance of counsel, they're stacking the deck against you.
Because they do have HOA side lawyers advising them every step of the way.
And resources beyond
You don't. You should. So, timing matters in these kinds of disputes, okay? This is true for many reasons, including the fact that problems develop over time, like evidence does disappear, right? Witnesses move. They leave the community. They go elsewhere. Statutory deadlines get missed, and once those are missed, they're gone forever. Narratives harden. Both sides harden, okay? Rights get waived. So, look, if you live in a bad HOA, the three things that I never want you to assume or believe, because these are always wrong, are, this dispute will resolve itself in time. When we deal with bad HOAs, that almost never happens, okay? Bad HOAs don't suddenly wake up one morning and those directors get a new lease on life and decide we should stop doing what we're doing. Doesn't happen. Or we have a lot of people tell us that they didn't contact us earlier because they believed in their heart of hearts that common sense would eventually prevail. Common sense is not so common, people. It doesn't eventually prevail. Or the HOA is going to do the right thing. No, if you got a good HOA, they'll do the right thing. Bad HOAs don't do the right thing. That's why they're bad HOAs. That's why we exist, because there are a lot of them out there, okay? In the real world, it don't happen. That's my colloquial way of saying,
no, it's true.
Don't believe those things, okay? So if you remember nothing else about this, mistake number 5 is early strategic intervention of an experienced HOA attorney more often than not prevents you from torpedoing your own case, and it prevents you from spending a lot more money than you had to. In other words, coming early enough saves you money. Sometimes a tremendous amount, sometimes a little. But money is money. Anything you want to add on that mistake?
No, I think that's pretty good. We covered a lot of ground. Okay. I mean, there are always nuances, but I think on balance, we covered quite a bit.
Those are the 5. Those are the top 5 mistakes. Again, I'll have the fact sheet, which discusses each of these 5 mistakes, in the description. Most homeowners, folks, don't lose valid HOA disputes because they're wrong or because the law or the facts are not on their side. A lot of people will lose those cases, or even before they become cases, because of what they've done wrong, because they violate one of the 5 mistakes we talked about today. Okay. California HOA disputes rewards homeowners who stay organized, who plan ahead, who keep their heads about them, who stay in good graces. They remain good members of the HOA, and then they do what they have to do to preserve their rights by hiring competent counsel, okay? If your HOA dispute is escalating, you have to know that the HOA has their lawyer already on staff advising them. You need to have that too. If you like this episode, please hit the like button. And if you haven't already done so, please subscribe to our channel, HOA Hell. If you want to leave a comment, as always, we'd love to hear from you. Until next time, have a wonderful day.